Okay, let's start. Good morning, ladies and gentlemen, distinguished speakers, respected academics, practitioners, students, and all participants who join us on site and online. Welcome. Today we gather to discuss a question that deeply troubling on the modern world. Why do modern slavery and human trafficking persist today? Globally, modern slavery and human trafficking remains one of the most serious human rights violations. It affects millions of people across regions, industries, and social groups. And it is taking various forms, such as forced labor, debt bondage, sexual exploitation, among others. And what makes this issue particularly alarming is that modern slavery persists not in the absence of law, but within the legal system that explicitly prohibit it. Almost all countries, including Indonesia and of course United States, have ratified international conventions, have adopted anti-national trafficking legislation, and declared strong commitment for eradication. However, in practice, trafficking networks still operate, victims remain unprotected, and the accountability of the perpetrator is often limited. This gap between law and the books and law in action raises critical questions about enforcement in the legal process. And it is precisely because of that today's presentation is being held. Ladies and gentlemen, this presentation is supported under the Fulbright program. It is designed as academic forum to disseminate research findings based on research conducted by UIDA as visiting scholars at Montclair State University in the United States, and also learn best practice and lessons learned from there. And through comparative perspective, we hope to deepen our understanding of why trafficking persists and how legal systems can be strengthened to respond more effectively. Before we proceed to the research presentation, we are honored to begin with welcoming remarks from our host institutions. This event is jointly supported by Parahyangan Catholic University, or UNPAD, and the American Indonesian Exchange Foundation, or AMINET. For the first remark, it is my pleasure to invite Mr. Adrianus Pitoramon as the Vice Dean of Faculty of Law of UNPAD to represent Parahyangan Catholic University to deliver the opening remarks. Mr. Adrianus, the floor is yours.
Thank you, Yunita, and very good morning for everyone in Indonesia, and also very good evening for our partner university, partner experts in the United States. And especially, I would like to also welcome and congratulate Dr. Susanti and also Dr. Francesca Laguardia, and especially Dr. Laguardia. I'm aware that currently it is around 9 p.m. Sunday in the United States. So thank you so much for taking the time and your opportunity to joining us in this very important case of views. Ladies and gentlemen, on behalf of the Dean of the Faculty of Law, Parahyangan Catholic University, I would like to welcome you in these very important discussions, and also to express my sincere appreciations to Fulbright, AMINET, and also all distinguished speakers, Dr. Susanti, and also Dr. Francesca Laguardia, and extend a warm welcome to all participants joining our discussion today. Fulbrights have long been known to play a very crucial and important role in fostering academic exchange and circulation of ideas between the United States and Indonesia. It is very important, in particular, our recent involvement in growth and cross-border and multidisciplinary discussions is held in a very constructive and very collaborative issues. One of our shared and ongoing challenges that founding our world today is modern slavery and human trafficking, which persists despite the adoptions of multiple national and international legal instruments and protocols, as well previously have mentioned by Ibu Yunita. This morning, UNPAD Faculty of Law, very proud that AMINET has selected Dr. Susanti for become the Fulbright US ASEAN Visiting Scholar program, and also for her research on the unfinished battle against modern slavery in Indonesian legal systems. We are also honored today, to welcome Dr. Francesca Laguardia from Montclair State University in that state, who will present the best practices from that state in addressing human trafficking. The Fulbright research presentation serves as a forum of discussions, disseminate research findings, exchange perspectives, and also strengthen the evidence-based academic and policy dialogue in the United States and Indonesia. I hope today's discussions will generate meaningful insight and strengthen the collaboration between Indonesia and the United States and contribute to more effective efforts in combating modern slavery and human trafficking. Lastly, I would like to also convey the greetings of the Dean of the Faculty, who is more than willing to personally join us this morning, but because of there is other parents that could not be represented, he asked me to represent him in welcoming you in these very important discussions. And I hope that we will have a very good and meaningful discussions and could contribute greatly to the better combating the trafficking in Indonesia and the United States. Thank you so much, Minister, and I return back to you.
Okay, thank you, Mr. Adrianus Pitorama, for your warm welcome. And now we are also honored to receive welcoming remarks from the American Indonesian Exchange Foundations, or AMINEF, the implementing organization of the Fulbright program in Indonesia. I would like to invite the representative from AMINEF, Ms. Mita Holmatia, to deliver their welcoming remarks. Please proceed, Ms. Mita.
Thank you so much, Ibu Yunita. Good morning, everyone. I am Miftahul Madia, the Communications Officer at the American Indonesian Exchange Foundation, or AMINEF, the Fulbright Commission in Indonesia. On behalf of AMINEF, it is my pleasure to welcome all of you in this Fulbright research presentation. This activity allows our Fulbrighter to disseminate the result of their research supported by the Fulbright program to a wider audience. And today we are especially honored to hear from Dr. Ida Susanti, a Fulbright US ASEAN Visiting Scholar who was affiliated with Montclair State University and also a lecturer at Universitas Catholic Parahyangan, who will share her research on modern slavery in Indonesia. And we are also thankful that Dr. Ida's counterpart in the US, Dr. Francesca Laguardia, also joined us at this event to share with us the legal and policy responses to human trafficking in the US. So we hope that today's session will inspire all of us and provide us with new perspective and also spark conversations on this important topic, both in Indonesia and in the US. Therefore, I also would like to extend our sincere thanks to Universitas Catholic Parahyangan and also Montclair State University for the collaboration in making this event possible. We believe that partnership like this enable us to share important research more widely and meaningfully. And last but not least, later at the end of this Fulbright research presentation, we would be happy to hear your feedback about this event. And therefore, for those joining us via Zoom, you will get the survey right after the Zoom meeting end. And those of you joining at Universitas Catholic Parahyangan, Unpar team will share with you a printed survey. Thank you once again to our Fulbrighter, Dr. Ida Susanti, and also to Dr. Francesca Laguardia, who share her expertise with us as well later. And of course, most importantly, to our partner, Universitas Catholic Parahyangan, who hosts this event on site. I wish us all an engaging and fruitful discussion. Thank you so much for the opportunity, and over to you, Ms. Yunita.
Okay, thank you so much for those welcoming remarks and also for AMINEF's continued support for academic collaborations. With those opening remarks, we will now proceed to the research presentations that forms the core of today's program. It is my honor to introduce our first speakers, Dr. Ida Susanti. Dr. Ida Susanti is a lecturer at Parahyangan Catholic University, Indonesia. Her research and teaching focus on international labor law and private international law, with particular attention to protection of migrant workers and the private international law approach to determining the minimum standard of protection for workers. She received a grant from the Fulbright US ASEAN Visiting Scholars Program to conduct research on decent work and the eradication of modern slavery. In this presentation, Dr. Ida will present her paper entitled The Unfinished Battle Against Modern Slavery in the Indonesian Legal System, which uses a social legal approach to explain why modern slavery persists in Indonesia despite legal prohibitions, focusing on legal authority gaps and judicial practice. Dr. Ida, the floor is yours. Your presentation time is 30 minutes.
Thank you very much, Ms. Yunita. First of all, I would like to thank to Aminef Indonesia and Fulbright Foundation to give me opportunity to present my research result. I would like also extend my sincere, delightful, and regards for Dr. Francesca Laguardia from Montclair State University, who became a very insightful person to discuss with. Thank you very much for that, and it is very honor for me to have the same floor with you. And also, I extend my appreciation for the Dean of the Faculty of Law, as well as the leader of this faculty, for giving me the opportunity to do the research at the USA. This is my research regarding the unfinished battle against modern slavery in Indonesian legal system. And before we start to discuss about what is the modern slavery, we have to see the figure in around the world. If we look in 2021, at least there were 50 million people worldwide in modern slavery, and most of them were engaged in forced labor. And if we look at the money or financial orientation engaged in that activities, there were at least 236 billion US dollar annually. So it is a very big money, and we are certain that there were or there are a lot of bad people who really want to preserve this illegal activities. And if we look at the terminology, there is one UN slavery regarding slavery, but this is using the traditional approach because we have to exercise ownership power over a person if we want to say about slavery. Now, it is very or it is not known anymore. There is such the traditional slavery exists in the world, but there are a lot of types of modern slavery that involve exploitation due to coercion or threats or indecent working condition for people who had been exploited. And based on Palermo Protocol, there are three components of modern slavery. The first one is the acts, that is including recruiting or transporting or harboring, etc. There is the means such as servitude, debt bondage, or forced labor, etc. And the last one is the most important, is the aim of that activity is to exploit somebody. So without any exploitation, no trafficking will be legally established. Regarding the modern slavery in Indonesia, there are at least two very important laws must be addressed. The first one is human rights law, because in that law, rights not to be enslaved has been acknowledged as non-derogable rights, and slavery and servitude are also prohibited, and they are classified as gross human rights violations. Unfortunately, if we look at the law, there is no statutory definition of modern slavery. Therefore, we need to find what is the meaning of modern slavery in recent years in Indonesia. And if we look at the law on anti-trafficking, slavery is still use the traditional concept because it needs ownership over another person. Therefore, we cannot use the slavery as the concept to eradicate the modern slavery recently. And there is another concept that is practices similar to slavery, in which there is somebody who have inability to refuse unlawful work provided by the trafficker. Therefore, we use a broader exploitation addressed through trafficking in person. And because of that concept, I will further use trafficking in person as the terminology to be used interchangeably with the trafficking, with the modern slavery, because the trafficking in person concept is also legally binding for Indonesia because Indonesia has ratified the Palermo Protocol. This is the figure of Indonesian trafficking in person. In 2024, there are at least 847 cases had been reported, but unfortunately, the total prosecution that has been successfully done was only 400 cases. So the successful rate is very minimum, that is less than 50%. And this is my research problem. The first one, I want to assess what is the socio-economic condition in Indonesia which contribute to the persistence of trafficking in person. The second one is what is the inadequate regulation in Indonesia which hinder their capacity to eradicate trafficking in person. And the third one, I would like to assess the court decision which also contribute of trafficking, eradication of trafficking in person more difficult. Then this is the socio-economic condition. The first the most problematic figure in Indonesia is there is a very huge gap between the job seeker and the growth of job vacancy. It is less than 35% gap. That is more than 35% gap in join job seeker and job opportunity, and it creates a very high unemployment rate in Indonesia because Indonesia is the highest position of unemployment rate among ASEAN countries. And there are also a very a lot of people live in poverty. More than 24 million people are living in the poverty line, which is only $35.71 per month. That is less than 600 rupiah for one person for 1 month. Because of that problems, the education in Indonesia is also very low, and it creates the mismatch between the job that is occupied by somebody. Another issue is the corruption in Indonesia, because there are a lot of people who are very permissive over the corruption, and it created a lot of problems before somebody has been recruited and sending to the country of destination. It involved the trafficker and also recruiter or intermediary people, or the transportation operator who try to bribe or who have bribed the Rsch official in Indonesia, such as the immigration officer or the Bureau of Population and Civil Registration. They help usually the trafficker in producing a forged identity card or passport, or even to help the smuggler to bring people trespass Indonesian border. So that problems is very big issue in Indonesia right now. And the second part of my research will be evaluation over Indonesian regulation, but I only pick some problems. The first one, this is the trafficking, human trafficking definition in Indonesian regulation. That consists of three components as well. The first one is when the human trafficking is the act recruiting, transporting, and transferring, receiving a person by means of threats or the use of violence or abduction, confinement, etc. And whether it is conducted within Indonesia, a country, or across countries, with the result of exploitation. So this is still in line with the definition in Palermo Protocol, but this definition is actually creating problems in Indonesia, because this is one example regarding the victim consent. In Indonesia, there are a lot of cases which actually acquitted the defendant from all of charges regarding trafficking in person, because there is a consent of the victim. Even though in Article 26 of anti-trafficking law, the victim consent does not preclude prosecution, but still, in fact, there are a lot of judges who consider the consent of the victim annul the exploitation or annul the involuntary involvement of the victim in that activity. And because of that problem, I propose amendment of the definition by literally involving the words of even with the consent of the person concerned, because it is very needed. If I learn from some cases in the court decision. And the second one is regarding the Article 3 and 4 of the trafficking in person. So Article 3 and 4 is regarding transnational trafficking in person, and in these articles, trafficker has been defined as any person who brings another person into Indonesian territory or another territory. In this concept, the mastermind or somebody who induced somebody else to do the human trafficking is not covered. Again, in many court decisions, there are a lot of mastermind who are acquitted from trafficking in person because they are not covered under this definition. Even though we are all know that if we look at the book of criminal code, of course, somebody who become the mastermind or who help somebody else or who order somebody else to do the criminal offenses, they must be penalized. But still, in the Indonesian judiciary process, unfortunately, the judges usually just interpret the regulation using only the what is it written in the law, and that is one of the biggest problem in Indonesia recently. Therefore, I propose also another amendment. The trafficker will be any person who bring or orders or induce other parties to bring another person to Indonesian territory or another territory, or any person who brings order or induce other parties to bring Indonesian abroad. That is my proposed definition regarding trafficker. Now regarding the victim, who are considered as the victim, there is an overlap between the protection of migrant workers and in the special law regarding the protection of Indonesian migrant workers and in the trafficking in person, anti-trafficking law. Because if we look at the protection of Indonesian migrant workers law, there is a preventive measure to and a criminal sanction to be imposed to the person who exploit the migrant workers. But unfortunately, the focus of the regulation is only to protect the legal placement of the migrant workers, while the illegal placement or such as the trafficking is not really clear, and it is not even mentioned in the protection of Indonesian migrant workers law. And unfortunately, in the Indonesian judiciary, there are a lot of cases which annul or which acquitted the person from any charges because the migrant workers was posted illegally, and therefore there is a gap for the protection of Indonesian migrant workers, and we need to be certain that the trafficking in person anti-trafficking law will be able to be applied to the trafficking of Indonesian migrant workers. Therefore, I also propose the amendment of the definition of victim. So this is the amendment of Article 1, Paragraph 3 of Anti-Trafficking Law. Victim includes Indonesian migrant workers suffering psychological, physical, sexual, economic, or social harm due to trafficking in person. So if there is a written if that is written in the regulation that migrant workers is included in the victim, then it will be certain for the judges to include the migrant workers as the scope of the protection of the anti-trafficking law. The third one is the judiciary in Indonesia. I just picked the three most controversial cases in Indonesia, even though in my research I involve a lot of judge decision. The first one is regarding the alternative judges in Indonesia. There are a lot of prosecutors who use the alternative charges in human trafficking cases because the prosecutors is in unconfidence to be able to prove the existence of trafficking in person. This is one of the example. Rusna versus Batam District Prosecutor. in which this case involving child workers who have been recruited to Padang city. In fact, she was never been paid, even though she has been promised to get the payment, the wage, but entirely during her entire working period, she never got the wage, and even she must be paid for her health protection. So this is a very she worked in a very bad condition, but the prosecutor used the alternative judges. The first is the defendant as a trafficker. The second is the defendant as the intermediary, and the third, child rights violations. Because this is the alternative judges, then the judges bypass the first and the second charges, and then directly to prove whether there was a child rights violation exists. And in fact, the defendant has been convicted for child rights violation, and she received a very significantly lower penalties, because the case is not was not treated as the trafficking in person cases. The second case, this is the one which is very problematic and gets a lot of attention from Indonesian communities. This is the case Terbit Rencana Parahyangan versus Tabat District Prosecutor. The case involving a lot of people, that is more than 600 people, had been confined in cages in the defendant residence. They were forced to work in palm plantation in a very bad condition, without sufficient meals, without sufficient water, fresh water for them to drink, and there were also physical abuse exists in that case, and there were 4 victims passed away because of very bad treatment in that plantation. The prosecutor charges under Article 2, Paragraph 2, anti-trafficking law, and alleged direct perpetration and conspiracy in trafficking in person. And the prosecutor demanded for 15 years imprisonment and 500 million rupiah for the fine, as well as restitution for that victims. But unfortunately, the district court acquittal. So the district court acquitted the defendant from all charges, because the judges held that no proven involvement of the defendant in the exploitation. The exploitation was actually done by an NGO, it is called Pemuda Pancasila, in which at that time the region of Langkat, Rencana Parahyangan, became the chief executive in that NGO. And the judges said that there is already other perpetrators who were liable for the pass away of some victims, and it had been also convicted in separate cases, and therefore the defendant were not the actor of the abusive treatment. And the exploitation was framed as a corporate conduct and not an individual liability, because it was done in a corporation, even though it was ordered by the leader of the corporation. So because of those decision, defendant acquitted of all charges. Also, it was very catching the attention of a lot of people, even the very outstanding NGO Contrast will become a defender of human rights in Indonesia, or even the National Commission of Human Rights and Judicial Commission has been forced to oversight the and supported the cassation of the case. And fortunately, the Supreme Court has annulled the acquittal of the lower court, and defendant had been convicted of conspiracy to commit trafficking in person. He was charged with the 4 years imprisonment and 200 million fine. But unfortunately, this decision is still not victim-centered justice oriented, because in fact, all of the restitution had been withdrawn, even though there was no examination whether the withdrawal by the victim was because of the voluntary withdrawal, or because they were forced to withdraw the restitution request. So still, if we look at the decision, even though that defendant convicted as a trafficker, but still it is not fully in favor of the victim. And another controversial judgment is regarding the victim consent. This is Puji Rahayu versus Mataram District Prosecutor, in which 2 minors, actually they were only 15 years old minors, had been recruited because they were living in very poor condition and they request for the job, and then they had been recruited and they were sent to Bali, and later they were moved to Lombok using the falsified civil registry documents, because they got the ID cards mentioning that they were adult. They were promised to get the wage and also tips, but actually it had never been paid. They locked up they live in a locked up accommodation, and they become the subject of 2.5 million penalty if they quit without the consent of the employer. In this case, the lower court has convicted of child trafficking, and there is a sentence of 5 years imprisonment and fines. But then, because the sentence was quite different than what was requested by the prosecutor, they considered it as lenient sentencing, and therefore they also appeal. And this is very surprising that the Supreme Court acquitted the defendant from all charges, because they, in the ratio decidendi of the court decision, mentioned that the victim had consented to work. And the judges also said that there was no forced labor, exploitation, or material gain, even though it was proven that the kids had never received any wages during the working period. So those are the very problematic court decision in Indonesia, and it has been happened because the judges usually just using the law as a written law, and there is no like a very contextual interpretation in the court decision. And this is my conclusion. If Indonesian wants to eradicate modern slavery, of course, the first we have to alleviate the poverty, to improve the education of the manpower, to decrease the mismatch between the job position and the competence of the manpower, and also suppress corruption. And regarding the law content, the content of the law, we need to revise some part of the law regarding especially definition of human trafficking, the coverage of traffickers, and the victims, the coverage of the victims. And also the prosecutors' empowerment, especially how do they can prove the trafficking in person to actually prevent the use of alternative charges, and to empower the judges as well to actively determine the need of restitution and to decide the restitution in favor to the victims. And judicial malpractice, misconduct eradication are highly demanded. So this is not combating human trafficking, actually not the destination, but we need a lot of process to make it possible. Thank you very much, and I give back the place to Miss Yunita.
Okay, thank you so much, Rita, for that insightful presentation. So through the research, we can see that trafficking in Indonesia cannot be effectively eradicated without addressing property, feudalism, and corruption. And of course, at the same time, Indonesian law and court rulings tend to provide greater protection for traffickers than to victims. And according to the research, largely due to formalistic legal interpretations. These challenges highlight the need of the amendment of the law, capacity building for the law enforcement officials, particularly judges and prosecutors. We will now proceed to our second speaker, Professor Francesca Laguardia. Professor Francesca Laguardia is the Chairperson of Justice Studies, College of Humanities and Social Science at Montclair State University. She was the former director of the Research Center on Law and Security at New York University School of Law. And Professor Laguardia has published on domestic terrorism, torture, and domestic counter-terror policies, as well as criminal law, criminal justice, abortion, and civil rights and liberties more broadly. Today, her presentation entitled Best Practices of the United States in Addressing Human Trafficking will offer a comparative perspective by examining how the U.S. legal system has responded to human trafficking. And for the background, the United States has criminalized human trafficking at the federal level since 2000 and has continuously amended its trafficking legislation while individual states have developed their own criminal and civil remedies. Professor Laguardia will highlight the best practice, and please proceed. You have also 30 minutes to present.
Thank you so much, and thank you for having me here. It's an honor to be asked to speak here. And thank you also for sending us Dr. Susanti, who was wonderful to work with over the course of her time at Montclair State. I'd like to take this time to offer an overview of what the U.S. has done and what has seemed to work in terms of our legal and policy efforts in this area. So as you just outlined, of course, all of us begin, when we begin talking about statutes on human trafficking, we always start from the Palermo Protocol in 2000, And the Palermo Protocol really highlights that trafficking occurs when somebody is recruited or transported or transferred, but under the threat or use of force or other forms of coercion or fraud. So we tend to shorten this in the US to force, fraud, or coercion as the key points that we need to highlight in order to make a claim of trafficking. Of course, this leads to problems, and many of the problems that Dr. Susanti was just describing are the problems that we've seen across all of the countries that have tried to enforce trafficking laws, which come down to how do you prove abuse of power? How do you prove that someone is abusing a position of vulnerability? How do you prove that someone has been coerced into something, particularly if there appears to be some level of suggestion that that person consented to the sex or labor relationship that they were brought into? And so it's important to remember that in this context, consent is meant to be irrelevant. Once we have seen that this relationship was created through the use of force or fraud or coercion, and coercion includes abuse of power or abuse of a position of vulnerability, then at that point, any consent should be irrelevant. In the US, we came to our statutes on trafficking at approximately the same time. There was a parallel process as Palermo was being debated. There was a parallel process in the United States considering what a human trafficking statute would look at or would look like. And we came to largely the same language, so that severe forms of trafficking is either sex trafficking, which is a commercial sex act induced by force, fraud, or coercion, or the recruitment or harboring or transportation into involuntary servitude, what we typically refer to as labor trafficking, but may also be referred to sometimes as peonage or debt bondage or slavery. So that is the beginning of the statutes on human trafficking, except that it falls into the same title, the same part of the US Criminal Code as all of our statutes on peonage do. And many of these statutes do date from the time when slavery was still legal in the United States. Even at that time, there were restrictions on how slaves could be transported or how enslaved people could be brought into the country and under what conditions. And so it is in that title, it's in that part of the US Criminal Code that we have put our more recent human trafficking statutes as well. And as Ms. Unita just mentioned, we have continuously amended these statutes. There are numerous amendments and refinements that we have made to these statutes, but some of them we have found to be more effective than others, or at least that's what the numbers look like. And so I'd like to point us a little bit more in that direction. So first, in 2003, along with our criminal statutes, we created a civil action so that victims were allowed a private right of action so that they could sue for financial damages and for to be brought back to wholeness to some extent, meaning that you should be able to sue for financial support in order to provide the psychological services, housing services, medical services that you might require coming out of having experienced trafficking. In 2008, we amended our trafficking statute to lower the mens rea that was required in order to obtain a trafficking conviction. We criminalized maintaining a victim. Instead of just actively trafficking someone, we also criminalized being involved in keeping that victim when you should know that they are a victim of trafficking, that they are being held against their will. But we also lowered a good deal of our trafficking statutes from intent to traffic someone to recklessness, to creating willful blindness, to using willful blindness to ignore the fact that this person is likely being coerced into the labor that they are performing. Then more recently, we started criminalizing items that we found tended to be more commonly associated with trafficking outside of the direct trafficking itself. So, for instance, in 2013, we criminalized confiscation of identification documents. That is, we know a common strategy that someone will bring someone to the country or even across state lines, and bring them in with promises of labor and employment, and then will take their visa or passport, will take any documents that identify them as legally being in the country, so that that person is then under threat of deportation if their presence is brought to the attention of the authorities. That practice of criminalizing the confiscation of those identification documents gave not just greater reach into a typical tactic that's used by traffickers, but also the type of thing that can be prosecuted using much more hard and specific evidence, so that it is harder for a jury to see this collection of confiscated documents and think that there's any way that that was something that these victims had consented to. In 2015, we also criminalized soliciting or patronizing trafficking victims. In 2017, we created more routes for the US to stop construction or other contractual obligations that the US believes is going to involve trafficking. This is a basic chart showing criminal prosecutions of trafficking in the United States. And there are a few things that I would like to highlight. First, that we start out with very low rates of prosecution under these statutes. And you see there's a very steep incline of prosecution about when we get to around 2008, 2009, and again about when we get up to 2013, right? We see very sharp increases. Now, I should warn you that there's a long history in the United States of it taking approximately 10 years for prosecutors to get used to new and important statutes that can be used to prosecute really heinous crimes. So, for instance, in the history of organized crime, the US relied very heavily on a statute called RICO, the Racketeering Corruption Act, which it took, in that case, about 10 years before we really saw RICO cases being brought forward, presumably because prosecutors just were not so familiar with the statute. The same thing happened with our anti-terrorism statutes, that the statutes came into place in 1996, but it took approximately 10 years before prosecutors really learned how to use those statutes, and we started seeing them being prosecuted more frequently, even though there was a massive terrorist attack in the United States in 2001. So to some extent, we might think that the increase is just prosecutors getting used to it, but there's also reason to think that it was what the statutes actually criminalized, and some of that goes back to both the research that others have done in the field, which I'm going to give a little bit of an overview of the literature review of kind of what has been found empirically in terms of what worked and what didn't, but also research work that I myself was involved in terms of sitting in roundtables with prosecutors and also doing in-depth research with local prosecutors in order to see what was prosecuted. I also just want to point out while I have this up, and we'll come back to this graph in a minute also, but the main prosecutions that you see here are sex trafficking prosecutions. And then labor trafficking is that tiny little orange bit at the bottom, right? We see far more sex trafficking prosecutions than labor trafficking prosecutions. And I'd like to highlight for you also that most of those prosecutions are sex trafficking of minors. So as I said, we started off with very low rates of prosecution. And what we've seen in the research is that much of those low rates seems to come back to the fact that prosecutors have a very hard time bringing these cases, in part because juries have a very difficult time believing witnesses who have been involved in criminal activity. So a trafficking victim is often someone who has been placed in the situation to engage in criminal activity, whether that is because they were sex trafficked into illegal sex work, or because the labor trafficking involved, again, hiding documentation, hiding someone whose legal presence in the country may be questionable, kind of echoes of those problems that Dr. Susanti was discussing in terms of migrant workers, right? That the claims of these individuals may well be dismissed by juries because the jury sees this person as untrustworthy because they were involved in something that was in some way criminal. On top of that, the experience of having been trafficked is extremely traumatic. And that trauma often leads people to have responses on the witness stand that are not necessarily understood by the jury and may be seen by the jury as suggesting that they are not telling the truth. So prosecutors can have a hard time presenting these victims to the jury as primary witnesses and getting the jury to believe them. And because of that, prosecutors rely heavily on physical evidence instead. Now, that may mean that cases where, again, cases involving sex trafficking may more often involve pornography that's created over the course of that trafficking, pictures that have been taken of abuse, and that creates this outside evidence that prosecutors can utilize. Additionally, victims often have a hard time in the United States. We've found victims often do not self-identify as trafficking victims. Victims themselves have a hard time believing that if they consented to get involved in this labor in the first place, if they consented to this job in the first place, that the law still understands that there may have been coercion involved in getting them to that point of consent. So victims do not necessarily self-identify, and it becomes very difficult for prosecutors to get them to come forward or to testify, and for law enforcement to do that. And in order to encourage law enforcement to do that, we have tried to train law enforcement to recognize victimization even when victims may not self-identify, and also to be able to speak more productively to people who may be traumatized and may be very unwilling to go back and relive that trauma over the course of testifying in court. And then we constantly have this question and this problem of what exactly coercion means. It can be very difficult to describe for a jury that something that is not blatantly physically forcing someone to do something can still be considered coercion. Now, prior to the Trafficking Victims Protection Act, which was when that main US federal statute was created in 2000, we understood involuntary servitude to require that kind of physical force. But over the course of the legislative record in discussing the passage of the Trafficking Victims Protection Act, there is record that the conference hearings specifically referred to the possibility of non-physical coercion. For instance, it specifically refers to one case where somebody threatened a victim that their family in an entirely different country would not be physically harmed, but would be ostracized in that area if that victim did not cooperate with their trafficker. And that was recognized as a form of coercion. But juries are still unwilling to see that level of non-physical coercion as coercion. Here we have what's actually written in the statute, that coercion can mean threats of serious harm or physical restraint, a plan or pattern tended to cause a person to believe that failure to perform an act would result in serious physical harm or restraint against them or anyone else. The abuse or threatened abuse of law or the legal process, that includes, again, taking someone's visa or identification documents and threatening to go to the police and identify them as illegally in the country. And we have this idea that serious harm can mean non-physical harm, right? Any harm, whether physical or non-physical. It can be psychological, it can be financial, it can be reputational, but we have a very hard time getting juries to believe that. This still is relatively vague, this federal statute. It suggests that the harm can be non-physical, but it doesn't necessarily give as many detailed examples that might convince a jury. In contrast, we might look to, for instance, the model policy in New York, which gives concrete examples suggesting, for instance, providing drugs to someone to impair their judgment, a plan to instill fear that can include causing physical injury or the threat to bring criminal charges or the threat of deportation or the threat of exposure of a secret or a fact that might be harmful to them, or misuse of a public position, right? Once we start really ironing out just how broad, in concrete terms, just how broad this coercion can be, we start seeing more willingness of law enforcement to act on it, of prosecutors to act on it, and of juries to listen to it. So again, we see here, and I want to remind you of what some of those amendments were that I mentioned before, right? So we see that jump up in 2008, which is when the mens rea requirement was lowered, right? And at that point, after we lowered that mens rea, we saw prosecutors much more willing to bring these cases. And in 2013, when we added criminalization of confiscation of identification documents, again, we see this jump. We see prosecutors much more willing to bring these cases. And we think that that may well be because it was that mens rea standard, the high mens rea standard, that was holding them back, that they were concerned they wouldn't be able to prove that, and because of that availability of concrete evidence. The civil litigation has been less effective. Again, you see a sudden spike in terms of civil litigation. That seems to coincide with more funding and the availability of larger groups of legal organizations with the ability to find funding in order to pursue these cases. But the number of cases is still really very small in comparison to the criminal cases that we see. I didn't want to spend a lot of time on T visas and U visas because it's a complicated area of law and I think it's less relevant to what you're talking about, but it's worth mentioning in terms of thinking about how to deal with, for instance, migrant workers, that one of the things that has worked in the past is that the US has opened up several different ways for individuals who otherwise could not legally stay in the country to be granted visas to stay in the country if they are willing to cooperate with law enforcement and testify, or at least cooperate in terms of the investigation, in order, if that will lead to prosecuting someone in one of these cases. And that is a way of the US showing that it is prioritizing actually incarcerating traffickers, but it is also a way to convince victims to be more willing to go through the difficulty of cooperating with that prosecution, to go through that process that might be traumatizing, to relive what has happened to them, and to go through the fear of identifying themselves to law enforcement and continuing to engage in this with law enforcement in spite of whatever threats they may be experiencing, right? This gives reason to go forward and to cooperate with law enforcement. Along with our federal laws, we have a broad federalist system. So we have states that can all criminalize trafficking in different ways and add support in different ways. It's only since 2016 that all states have criminalized human trafficking separately from the federal government. There are many different things that states have tried doing, including, again, lowering burdens of proof for convictions, offering restitution options. That's a way for a prosecutor to obtain money from a trafficker and use that money to support the victim in order to get their own housing, in order to get their life together, in order to get psychological counseling, in order to get medical aid. Also, the chance of removing prior convictions, that the trafficking victim may have been convicted of crimes while they were that they committed under the threat of force while they were being trafficked. And we can expunge those convictions. We can make them no longer legally relevant. And that's another reason to encourage, or it's another way to encourage victims to come forward and cooperate. And then there's also the investment that can be made in training specialized units, in training law enforcement to know how to recognize these cases and how to speak to victims. and in providing services, in providing legal services for victims, in providing hospital services, therapy services. All of these things can make it more possible for victims to identify as someone who will be protected and to come forward and collaborate in the prosecution. And that collaboration is so necessary because it is very difficult to prove that someone has been involved in this activity against their will unless that person is willing to come forward and say that in court and run the risk of being cross-examined and run the risk of being continually threatened by their trafficker. All right, so there has been some empirical work in terms of which of these strategies has worked best, and I thought that might be worthwhile for us to take a look at. So of the things that have been most effective, you can see a statistically significant result in regards to times when we have invested in training law enforcement officers so that they can recognize these things better and so that they can speak better with victims, so that the victims are more willing to speak with them. And we nearly double our prosecutions to a statistically significant level. We nearly double our prosecutions when we lower the burden of proof for minor trafficking victims. And I want to remind you in that chart in terms of what were the most common cases that we saw. And when we've spoken to prosecutors, what are the cases that get prosecuted the most often? They are prosecutions for sex trafficking of minor victims. And prosecutors will tell you that in large part that is because the question of consent does not come up with minors, because we know we have long established in US law that minors cannot consent to sexual activity. It does not matter what they say. We consider them incapable of consenting. So consent no longer is a problem in those cases, and so those cases get brought far more often. Other things that have worked, creating higher penalties seems to work. That seems to be because prosecutors read that higher penalty as a sign from the legislature that the state is interested in taking these cases seriously. And when the state is interested in taking these cases seriously, that is good for a prosecutor's career, as well as being a sign that they will be supported if they bring these cases. And so an increase in penalty seems to work, but not to the same statistical significance as the prior two that I talked to or spoke about. Restitution for trafficking victims seems to increase prosecution, but civil actions don't. So that means when the victim has to have their own lawyer to pursue those financial damages, that does not aid in bringing more prosecutions. But when the victim might get financial aid back as part of the criminal prosecutor's case, as a result of the criminal prosecutor's case, that does result in more cooperation and more prosecutions. Allowing trafficking victims a defense to the crimes that they have been charged with creates more prosecutions and more collaboration. Funding for victim services leads to more charges against offenders, but not necessarily under trafficking statutes. So often when prosecutors don't think that they can prove a trafficking case, they will charge that defendant with something else that they do think they can prove. Like, for instance, running a prosecution ring without the coerced trafficking aspect of it. We see that those prosecutions go up if we fund victim services more. And creating multidisciplinary, multi-agency human trafficking task forces. That means creating groups of individuals, including victim services organizations, including federal prosecutors and state prosecutors, including law enforcement and the prosecution, all coming together, discussing these cases from multiple different interdisciplinary angles, and then planning how to respond to them together. Those are things that have made real differences in terms of how often we prosecute these cases and how successfully we prosecute these cases. So that is, I'm just double checking my notes. That is all that I wanted to highlight to you. I do think it very much supports and reinforces what Dr. Susanti has spoken to in terms of the problems of consent. We are seeing those problems everywhere. This is how the United States has dealt with those problems, and this is where it seems to have worked. Thank you. And I look forward to your questions.
Okay, thank you so much, Professor Laguardia. It's a very insightful discussion. It's very inspiring for me, especially that we need a lower burden approach for minors, and also to have a capacity building and lots of strategies that Professor Laguardia has mentioned to us. Now we will move to the discussion and Q&A session. To begin, we will start with 3 questions. Will be addressed one by our speakers. I kindly ask each participant to state your name and institutional affiliations and to indicate the speaker that you address to. For on-site participant, you can raise your hand. And for online participant, you may raise hand feature on Zoom. Yeah, one here and the other side and Zoom. Probably we will hear the first questions.
Good morning, everyone, and thank you for both speakers for these very insightful presentations. And I got 2 questions, and each will be for the respective speakers or Ibu Ida. Can you kindly enlighten us with the recent, probably for the past 2 to 3 years, increase of victims that mainly trafficked into the region, Southeast Asia, especially for online scamming industry? How those the root cause of these problems, and what's your take on the issues, and how you probably see the most possible way to mitigate the issues. And for Dr. Laguardia, probably I need to apologize at first because it's probably quite close with political issues. And see, right now I'm still apology for the questions, but I really need to know that how the issues are being discussed right now in broader terms of the immigration policy in the United States. The media information in that is being received in Indonesia is a quite large immigration operations right now ongoing in the United States. I know it probably only in several cities, probably several states, but how the issues of the trafficking persons correlate with these issues of immigrations at large. Thank you.
Okay. Should we ask more questions or? Okay. Mas Bilal Dewansyah, please state your questions, please. Mas Bilal. Okay, the second question will be from Mas Bilal and the third from Mbak Siti Arieta ya. Mas Bilal, please state your question.
Thank you, Bu Yunita, for the opportunity. Thank you also for the interesting presentation for Dr. Ida Susanti and also Professor Laguardia. So I will start. I have 2 questions. First is for Dr. Susanti. It's so I'm not really researching about trafficking. I'm researching a lot on refugee issue, but I think it is sometimes connected. The issue, as you also mentioned, is also in Indonesia. I think trafficking mostly also happen to migrant workers, right? And then you also like suggested to amend the law to give more clear definition on victims. But we also like seeing that in Indonesia, there's also refugee that becomes victims of trafficking, cross-border traffickings, and also intertwined with the smuggling issue, right? Do you see this is also something important to address alongside with the migrant workers protection or not? Because it's I mean, migrant workers also have vulnerability, and then we also have a refugee population, which is also they've been trafficked from Indonesia, mostly Rohingya, from the Bangladesh, and then to Indonesia, and then trafficked to the Malaysia. When we don't have any clear approach to handle this issue, especially perceive them as victims. So I curious to know, how do you think about these issues? And then second questions to Professor Laguardia. It's also, I'm curious to know, because you also mentioned that a lot of federal laws in the US on trafficking also, related to the documents on the traffickers, on the victims, right? So my question is how it's connected to, I don't know, like smuggling of migrants or people smuggling. And then in the US, is there any law that also protects asylum seekers or refugee for the cross-border traffickings as the victims of these crimes? Thanks. Waiting for your response.
Okay, thank you, Mas Bilang. The third question from Mbak Siti.
Okay, thank you so much for the opportunity. I'd like to raise my sincere appreciation to my teacher, Ibu Ida Susanti, as an alumni of law studies in UNPAR back in 2001. I'm Arita, and I'm currently teaching for Faculty of Social and Political Sciences in Universitas Maritim Raja Ali Haji Tanjung Pinang. So I'm quite familiar with trafficking issues since we're in Bintan Island, and somehow in terms of speaking of trafficking issues, Bintan somehow, comparing to Batam, is more likely underrated, even though like we do have illegal port that transport the victims. Even though I'm not becoming the main researchers in that area, but I do have my concern, especially when I'm doing the research about the community, since I'm now now I'm the lecturer in sociology department. So my first question is to Bu Ida, since you mentioned about poverty in your conclusion, and I do realize that in that abandoned harbor or the illegal port in Bintan, and because it's really close to the sea nomads sedentarization. So I just wondering, so beyond the state institutions, how can local communities and also the customary or the sea nomads leaders and the community, or even the maritime social institute like Fisherman Group, because they're also familiar with that. They during the fishing activities, they are familiar with, oh, this boat is taking the workers, the legal workers, to Singapore or to Malaysia. So how can these actors be systematically integrated into national trafficking frameworks as recognized actors? Because they're the one who can do the early detection or even prevention and victim support. So that's my question for Ibu Ida. And for Professor Laguardia, because you mentioned that now state law, there are state law in human trafficking, there are fully institutionalized out of the federal law. So now it's in line. But how is the process of the making that state law, like, is it smooth process, or maybe there are some things that really not really in line with the federal law. So I would like to know in terms of the state law and federal law. So those are my questions. Thank you so much.
First, Professor Laguardia wants to answer first for Guida.
As to the discussion on trafficking and how it coincides with the discussion on immigration, I think this is an incredibly insightful question. And it is frustrating, I think, for those of us who work in looking at trafficking at all, that the discussions have remained in the last couple of years almost entirely separate. There's decades of research on the myths of trafficking and the ways that we assume only certain people get trafficked or that only certain people engage in trafficking, and how incorrect we tend to be. And we have some of those myths reasserting themselves, but even that, frankly, we haven't heard as much about in the past couple of years. For the most part, the argument on immigration has remained entirely separate, even as funding for organizations that look at trafficking gets cut. And that has largely flown under the radar. It has not reached the public discussion very much at all. And that is very frustrating for many of us. But then because it has not reached the public discussion, we don't have the kind of reporting on the ways that changes to visa practices or the threats of deportation may have aggravated trafficking in recent years. We don't know yet, but it would be a likely result given what we saw in prior terms when there was much more harsh responses to immigration. As to how trafficking is related to people smuggling, it can be. It can also be incredibly local. I think people underestimate how small and local trafficking can be in the United States. It can be as much as focused and as domestic and as individual as a single boyfriend who abuses his girlfriend, or someone who sells drugs and finds children that he can coerce into doing it for him, or finds somebody who has been arrested for other crimes or is under threat of arrest and therefore uses that threat of arrest in order to force them into other illegal behavior. So is it connected to people smuggling? It can be, but it does not have to be. Are there laws protecting asylum seekers? Of course. If you're an asylum seeker, you are legally in the country from a de jure perspective. From a de facto perspective, from the law, how it's actually applied right now, that may not be respected. If you are considered not legally in the country, then you fall under the same visa protections as anyone else who came into the country without the proper legal documentation. As an asylum seeker, you should be considered to be legally in the country, in which case the standard statutes against trafficking would apply to you. And as to the final question, where do state laws differ from federal law? State laws have gone in all different directions. In some states, they're offering more protections than the federal law does in terms of expunging convictions, in terms of offering resources and financial support. In other states, they're not offering financial support at all. It has been the most common state response has been simply to criminalize trafficking, the criminalization of trafficking typically echoes fairly closely the federal criminalization. It's based on the idea that you are forced into labor or sex labor through force, fraud, or coercion. And it doesn't usually wander that far from that federal outline. But all of the extra aspects that can be incredibly useful, including providing victim services or conducting reporting, can vary. And in some cases, the federal government is more active in those areas. In some cases, the state governments are more active. Some scholars have suggested that criminalization is the thing that happens fastest and most commonly because it doesn't actually cost anything. You just write a law and say that now this is against the law, and then law enforcement are empowered to arrest and prosecutors are empowered to prosecute. There's no outlay of resources required in order to put that law in place. In contrast, requiring some kind of reporting or investigation or putting together training or putting together resources for victims in order to encourage them to come forward, those things all cost funding. And so we see those coming about less frequently and less easily.
Okay, thank you so much, Professor Laguardia. Lida, you want to answer the...
Okay, thank you very much for the questions. The first, regarding the online scheming industry around Asian countries. Actually, there are a lot of Indonesian victims who are still in many countries like Laos, Republic, or Myanmar, or Cambodia, and we know that they work under a very clandestine condition, and many of them really want to escape from the recent condition, but unfortunately, because it is a kind of systemic or organized crime, it is very difficult for them to get out from that condition. One of the most problematic things is the involvement of the online scammer, because when they were recruited, they were forced to do the online scamming, and then they didn't like the job, and sometimes they want to escape, but unfortunately, they are not really free to go away from the place where sometimes they had been confined. And one of the most difficult condition is sometimes if they want to get back to the home country, they have to find the substitution. So they invited the closest people, like the family members or sometimes the neighbors, to substitute them. And when the case becomes the law case and there is a law enforcement, it is very difficult to define them as the victims, merely the victims, or also the trafficker, because they invite somebody to come, because they recruit somebody to substitute them. So it is a very problematic case recently, and even because it is very covered, even the Ministry of Foreign Affairs is also still having a struggle to evacuate the victims. Then, however, I can address this issue. Until now, it is still ongoing process, and we haven't had any clear solution yet. But the one that I really concerned is regarding the victim. It is they become the victim, they suffered from that condition, and there is no way to make them become the trafficker as well. That is my main concern. And regarding the refugee, There are a lot of refugees who come in Indonesia illegally. They trespass the border of Indonesia, and it becomes a very big issue, especially regarding their position in Indonesia, sometimes illegally, and they cannot access the labor market, even though sometimes they try to find the job to survive. And therefore, that is the vulnerability that sometimes become misused by somebody else, and they are forced to work in a very bad condition. And it is covered, and it is very difficult to find the solution. Actually, I'm not really familiar with the refugee protection, but as far as I know, Indonesia is not the member state of Refugee Convention. Therefore, we cannot, we don't have any obligation to impose the minimum standard of protection for the refugee in that convention. So if Indonesia try to protect the refugee from the trafficking, it is just because it is done voluntarily by Indonesia in the sense of human rights protection. And it is very important for Indonesia to facilitate them to get connected with UNHCR, because UNHCR actually the main international organization who usually provide the protection, such as in some detention houses in Indonesia, they provide like the stipend for the refugee to make them at least having living costs, and it is decrease the vulnerability of that person. So that is just a common thought, but I haven't taken it deeply. I'm sorry if it is not will cover your question. And regarding the poverty, indigenous people, indeed, we know that in Rio Islands, there are a lot of indigenous people who work as a nomads, and then they are having the competence to do the fisheries, even though it is based on traditional fisheries method, but because many of them are also living in a very basic condition, I cannot say poor, because maybe they have a connection very well with the nature, and sometimes they can use the nature by their local knowledge. But still, if the government can involve them into the tasking force to at least minimize the trafficking in person in those areas, because there are a lot of Indonesians who are forced to work in indecent condition in fisheries, and I am certain that the nomads leader will be able to contribute to at least identify in what sectors the trafficking has been done, where is the hotspot of the human trafficking in that area, because they know well the territory, and also the places which are beyond the control of the government. So having them as the contributor to at least minimize the human trafficking is very important. Thank you very much for the question.
Okay, thank you so much, with that. We will now open the second session for the Q&A. From the on-site participant, is there anyone who wants to ask questions to the speakers? One. There's another one. From online, is there anyone who wants to raise the questions? Please use the raise hand feature on Zoom. Okay, for the first question from the outside, Mbak Novi, please state your questions.
Okay, thank you very much, Mbak Yunita. Bu Ida and also Professor Laguardia, thank you very much for the presentation. I learned a lot, especially from the Indonesian and US point of view. So thank you very much for that. Disclaimer first, I'm not coming from the law faculty, first of all. I'm coming from the social politics, especially from the IR. So I'm not going to talk about the law because it's not my specialty. But I would like to agree for both of you. So maybe start with the comment first. I agree with both of you about the concept. Yeah, especially looking from the gender perspective, especially from Indonesian point of view. In many cases, especially like Professor Laguardia mentioned before with the sex workers, the consent is not, how to say, it's not genuine anymore. Because Indonesian culture is like, malu-malu, like shy and sungkan, or not very, how they not speak frankly. So then maybe they say consent somehow, but then it's not consent. So then it's very hard to say whether it's a fully consent or not fully consent. So I agree with both of you that we have to consider about the consent from especially for the law point of view. The second one, I also agree about what Ida mentioned about the mastermind, Ida. Especially when we discuss about the trafficking and mastermind, or sometimes in the people talking about the mafia, yeah. So it's not about P2P or person to person, but person into the whole game of mafia that operates the trafficking. So I really agree with your idea to think about the mastermind. And the third one is about the documented and undocumented data. I would like to raise maybe a question or maybe like a critical point of view. When you mention about undocumented, from my point of view, sometimes they go documented actually, but the document is not the legal one.
Yeah.
It's a fake document, yeah, from the KTP, KK, and so on and so forth. So then basically, I would like to critically ask you about the term documented and undocumented, especially in terms of the legal and unlegal or illegal documented. And then, sorry, I come up with several things, Bu Ida, just to make you a bit confused, Bu Ida. And also about the Pemuda Pancasila, Bu Ida. Is it NGO?
Oh, I don't know.
Or like in Indonesia, we use terms ormas, right? Organisasi masyarakat, yeah. But in English, okay, I know it's a bit hard when we translate into English. Is that NGO or CSO?
CSO.
Civil Society Organization? Because when we mention about NGO, mostly it's for like formal organization that is non-profit, not connected with the government, and so on and so forth. But when we talk about Pemuda Pancasila, even though I know the vision and mission is very good back then, ages ago, but now the story with the Pemuda Pancasila is kind of totally different. So it's just a comment. And the last one is about the poverty, Ida. In the conclusion, you mentioned that the things that we have to handle first is about the poverty. Once again, Bu Ida, I would like to critically ask you, is that true? Because you mentioned also about the corruption as the third point of view. But then we know that the corruptors coming not from the poor people. They already rich, but they still corrupt.
So is that poverty is the main issue that we have to educate, yeah? Or the education and awareness and also the value of the community to see that money is not something like, like you have to pursue with the illegal and so on and so on. It's just like, things that make you maybe like critically thinking with them. Thank you, Bu Yunita.
Okay, thank you so much for critical inputs, Mbak Novi. From the online participants, you may raise your hand through Zoom. Is there anyone who wants to raise a question? And okay, maybe we will wait. Vida, maybe you can respond to the questions.
Okay, thank you very much, Mbak Novi, for the critical questions. If we talk about documented and undocumented, indeed, the documented migrant workers is the workers who were use the legal documents without any forgery or any fraud to get it, and this is one requirement for somebody to be considered as a person who has been placed in other country legally or lawfully. And that is the scope of the protection of Indonesian migrant workers law for protecting the legal procedure as well as legal document of the migrant workers. Sometimes we can uncover that basically the documents is produced based on forgery, so that is not documented migrant workers, because everything which is come from illegal activities will break the status of that person become illegal as well, and therefore it goes beyond the protection of the law on protection of Indonesian migrant workers. The second one, that is my bad, because I didn't have very deep thinking when I mentioned that Pemuda Pancasila is an NGO. But I agree with you, that is more civil society organization instead of NGO, because especially with the very bad track record of Pemuda Pancasila, it is impossible to call them as an NGO. Thank you for the correction. And if we talk about the socio-economic problems in Indonesia, actually we cannot say which must be the first. Because when I said the first, we have to alleviate the poverty, eradicate the corruption. I was thinking that is one of simultaneous activities that must be done in parallel. Like, of course, having a better education for creating the awareness of the people would be a very important step. But we also know that that is part of a very never-ending activities, because the progress is always ups and downs, as we experienced regarding the child labor. Actually, that is ups and downs. In 2008, it was a very, very good progress to eradicate forced labor, child labor, but now it appears re-increase. So I think, education is very important to create the awareness of the people, to know that every coercion, every exploitation is bad and we have to eradicate them. But sometimes the majority of Indonesian people are not in the position to correct that because they are also vulnerable people because of the poverty. So we cannot say which one must be the first, but we have to do it simultaneously, I guess. Thank you.
Okay, thank you, Vida. Now the time has shown to 10:50, which is actually the end of our discussion today. As we have come to the end of the today's sessions, allow me to highlight a few key reflections. Like today's discussion has shown that the persistence of modern slavery is not a merely legal problem, but actually a complex interaction of law, socioeconomic vulnerability, and institutional practice. By bringing together Indonesian and US perspective, this forum has underscored the importance of comparative learning. And on behalf of the organizing committee, I would like to express our sincere gratitude to Dr. Susanti, Dr. Francesca Laguardia, for their valuable contributions, and also to Ulfar and to Aminah for the support of this important academic exchange. Before we officially close the session, I would like to invite all the speakers and participants to remain for a group photo session. For the on-site participants, we say seated, or is there anything that we should do for the photo group sessions? And for the online participants, please kindly turn on your camera if possible. We will take the photo group shortly. So should we see it here for the on-site?
No.
Or here, like this? Okay, so we will stay like this. For the on-site participant, we please leave it and for the online participant, please I need to turn on your camera. That's it. See that?
Behind you.
Oh, okay. Okay, so keep seated for outside. We are sorry for the hybrid session. So for the outside, okay. Okay, 3. Okay, we will take the group photo shortly. 3, 2, 1. And for the online, we will do this picture. Okay, 1, 2, 3. Okay, thank you very much. Okay, thank you for all participants, for the speakers, Vida, Professor Laguardia, Aminah, Ulfar, everybody. Thank you for your engagement and thoughtful questions. This presentation is now officially closed. Thank you.
Thank you.
Thank you.
Thank you, Francisca. Oh,
Thank you so much, everyone.
thank you.
Thank you. Good evening, everyone.
Terima kasih semuanya.
Terima kasih Bu Ida, terima kasih Aminah. Thank you all.
Ya, selalu sehat.
Izin live ya.
Thank you.